Welcome to Off the Clock, a podcast by Procino-Wells and Woodland, where we take a team-centered, family-focused approach to serving the estate planning and elder law needs of our community in Delaware. I'm Megan Seksinski, Director of Community Relationships here at the firm, and I'm joined today by Katie Heald, one of our attorneys. Today we're covering some incapacity planning updates, so let's get started. Hey Katie, how are you?
Doing good. How are you?
I'm good too. No need to waste any time. Let's get right to telling our listeners what we mean when we say incapacity planning or lifetime planning.
Yeah. So incapacity, or otherwise put, lifetime planning, is the way that we address decisions that need to be made during our lifetime. So this includes a power of attorney and your Advance Health Care Directive. We actually spoke about these a little bit ago in a previous podcast. So I would direct any listener to listen to those. They do a good job of kind of queuing up what we're speaking about today. So a couple that come to the forefront of my mind are the incapacity planning podcast that covered the power of attorney and advanced healthcare directive very thoroughly, as well as estate planning for young adults. That podcast talks about how in Delaware, when you turn the age 18, you're considered a legal adult. So those documents are really essential. And then also within our Power of Attorney podcast, we spoke about adult guardianships, which is the process of essentially naming a guardian if a client is no longer has the ability to execute that power of attorney or advanced healthcare directive.
You're right. Today's episode can really be considered a sequel of sorts in that we are discussing two real legal updates that came into Delaware law recently and primarily touch the Advance Health Care Directive. So the first is the Uniform Healthcare Decisions Act, effective September 30th of 2025, and then the End of Life Options Act, signed May 20th, 2025, both last year. So let's get right into talking about the Uniform Healthcare Decisions Act and what actually changed with that new law.
Yeah, sure. So the Uniform Healthcare Decisions Act, the latest of 2025, it did not repeal the previous 1993 Act, but it more so supersedes. So it was intended to modernize and to expand upon the prior version. So I just bring that point up first, just to ensure listeners that their current documents are okay. But it is always best practice to review them and make sure that their wishes are still reflected properly. But the new act really just was created to expand upon the prior version in 1993 and kind of modernize it to 2025. So, with that being said, one of the things that the act did was it modernized our incapacity determination. So the new Advanced Uniform Healthcare Decision Act actually recognizes that capacity isn't an all or nothing, right? It's something that someone might have the ability to make decisions regarding one area of life, but maybe might not have the ability to make decisions in a different area of life. They also, in the act, expanded upon the method by which we discern capacity. So, unlike the prior act, where verbal communication was really the method that we use to discern if an individual has capacity, the new act has explicit language that essentially says there are different methods for someone to communicate if they have capacity. So, the actual language that the statute uses is can you discern capacity through appropriate services, technological assistance, supported decision making, or other reasonable accommodations? And so, some examples, right, of what that would include is maybe, body orientation, movement, eye gazes, gestures. This makes me think of a guardianship case that I served as an attorney ad litem, where the mother of the person with the alleged disability had figured out that her son was able to communicate through his eyes. And so she had a yes and a no board, and she would ask her son questions and would hold up the board. And sure enough, based on the question, he would look at yes or no based on his thoughts. So just an example of another way that a person can communicate whether or not they have capacity and their answer to a said question. But it's important to note too that in the Advanced Healthcare Directive and the new law that an agent's authority only kicks in once they are incapacitated, once it's actually determined that they do not have capacity. One thing I like to always point out to clients when they come in to create an advanced healthcare directive is this does not by any means permit the End of Life Decision Act, so mercy killing or euthanasia. They're two totally separate things, and it's really important to kind of distinguish between the two. We'll get into that a little bit later. But also, the new Uniform Healthcare Decision Act eliminated some of the prior administrative barriers that were in place before a document could be properly executed.
Otherwise known as signing formalities. So those administrative barriers really capture those. What did the old signing formalities look like, and why does making them easier to navigate help people get a directive in place?
Yeah, so one of the biggest previous signing formalities that was a bit of a burden was the ombudsman requirement. And so essentially what that was is the requirement that if a person wishes to execute an advanced healthcare directive within a nursing facility, they needed an ombudsman. They couldn't use the facility staff to witness their documents, which really does create a hurdle, right? It's another person that you need to get to the facility to formally execute the documents. So the new law has expanded to say no longer is an ombudsman required, and the new formality says that only two witnesses or a notary is required in order for the document to be properly executed. Interestingly enough, the statute also allows for electronic signing and remote witnessing. So just another kind of way to break down those barriers, whereas previous to this act, it wasn't permitted. The act also speaks to mental health. So this is a large part of the Uniform Healthcare Decisions Act, where it essentially allows for people to state their general philosophy or viewpoints on their mental health. The option is there to either incorporate that mental health language within your existing advanced healthcare directive within the same document, or you can actually execute a different document that focuses solely on your mental health and your preferences. So that's a question that, you would have to speak about with your practitioner if you want to execute that document and include that language. But the act also allows you to say, or rather nominate two separate people, one for maybe more healthcare decision making, and then another for mental health decision making. So kind of really important additions that were made to that act or to the Advanced Healthcare Statute. Also, another thing that it did was it modernized the default surrogate list. So in the absence of having an advanced healthcare directive, who is next best in line? Who do we want to make decisions for us? So the new act now includes, whereas previously it was first spouse or domestic partner, it has now been expanded to include adults, children, parents, cohabitants was a new addition, siblings, and adult grandchildren. Kind of very interesting that it's really expanded upon the list of possible people that could be put into that position to make decisions for us. Of course, we always want to have our documents in place, but this is essentially the law's effort to put next best in line in the absence of those documents.
So, a common example of maybe a non traditional household that we see a lot is maybe a long term couple, but they're not married. They don't have the formality of a marriage certificate. So, can you use that as an example to talk about how these modernizations matter for these non traditional households?
Yeah, I mean, it's huge, right? Prior to this new act, unless you had those formal documents in place or were married, the assumption is that you cannot make these decisions for someone that you otherwise treated like your spouse. So this act has addressed the fact that is a lot of people in our community, right? That applies to them. So it's always the law when they come up with these, default decision making people. It's always their attempt to really answer, this person did not formally execute a document, right? They haven't expressly told us who they like to name, but we want to at least name someone that we think is next best. It reminds me very much so of Delaware's default laws of intestacy. So if you pass away without a will or without a trust, who gets your stuff when you're no longer around? And Delaware has a list of priority of who gets what. And it's their attempt to answer who and predict who the decedent, the person that passed away, would have preferred to receive their things. It's very similar with this act in who is next best in line to make these decisions.
Thank you for summarizing all that information. That really puts, a pin on the Uniform Healthcare Decisions Act, which is totally different from the End of Life Options Act, a different law entirely. So let's switch gears and talk about that change and legal update.
Yeah. So, what does it allow? What does the End of Life Decisions Act say? So it was signed into law May 20th, 2025, and it essentially permits terminally ill adults to request medication to end their life. However, there are certain safeguards that are built in place to ensure that their decision is informed and also voluntary. The qualifications that are required in order to utilize this act are that a terminal diagnosis of 6 months or less must be given that is confirmed by two medical professionals. The patient must have decision-making capacity. So, the ability to understand and appreciate the nature and consequences of their decision. And then they must have two oral requests to utilize this method, as well as one written request. So those are the qualifications, but there's also protections that are built in place. And one that I always like to point out when it's brought up in meetings is all physicians have the right to refuse the ability to use this medication for their respective patients. Importantly, as well, is the fact that only your agent under an Advance Health Care Directive will never be able to sign this documentation for you or make that decision. It is only ever permitted to be something that you do for yourself. Nobody else can request it on your behalf. The physician is required to discuss all other end-of-life options first, so pain management, hospice, things like that. And there's also two separate waiting periods before the medication can actually be administered. So patients, of course, retain the right to change their mind at any point. But these are just a few of those protections that are built into this law. Funny enough, before hopping on, I wanted to see if there was any statistics as far as if this law has been utilized yet. And my understanding is that in the end of this next year, the Department of Health and Social Services will have statistics as far as the if this has been used or not, this new act. So it'll be interesting to see.
So some common questions that come up related to this include, does the End of Life Options Act affect an existing healthcare directive?
It doesn't. And it doesn't because they're two separate things. So, the Advanced Healthcare Directive applies in a situation where you no longer can make health-related decisions for yourself, whether that is healthcare or mental health related decisions. Whereas the End of Life Options Act is applicable in cases where you still have the ability to make decisions for yourself and you're choosing to utilize the End of Life Decisions Act because of a terminal condition. And that's a personal decision that you make. So in one scenario, you no longer have decision-making capacity. You can't make decisions. And in the other, you're very capable of making decisions, which is why you're choosing to pursue the use of this act.
Mm-hmm. So you've pretty directly answered this question, but just to make sure we're really clarifying for our listeners, if someone's interested in the End of Life Options Act, do they still need a healthcare directive?
Yes, 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 yes. Like I said, the Advanced Healthcare Directive applies when you can't make decisions for yourself. So it is incredibly important to have that document in place. While the new act has, expanded upon the list of default surrogates to make those decisions for you, it's, it's never a substitute for your own plan where you have expressly designated who you wish to make those decisions and talk to them about why they're named and your hope. So you always will need an advanced healthcare directive, irrespective of any decision to use this or not.
Mhm. Let's circle back to the rights that providers retain related to this new law. Does moving into a nursing home or any type of care facility affect a person's right to use the End of Life Options Act?
Similar to physicians' ability to refuse the use of this act, nursing facilities and homes also have the ability to say that they do not wish to allow this to be used on their premises. So it's similar in that.
Mhm. Is there anything special to think about from an estate planning perspective after a terminal diagnosis has been received?
I think it's always a great time to review your documents and ensure that you have the proper people named that will follow through with your wishes. Maybe look at beneficiary designations and if you have certain people named in proper places. But it's always a good time to review when there's a big life change, such as a terminal illness, and just to ensure that your plan is the plan that you're still comfortable with, and the people that are named, you're comfortable with them and trust them to execute the plan that you have designated as such.
Mhm. Really good. Katie, this is great information. Thank you so much. Let's circle back and do a recap for our listeners. Let's go back through the legal updates that we're covering today and provide a really quick Cliff Notes version of the changes in the law that we're discussing.
Yeah. Yeah. So the Uniform Healthcare Decision Act has updated how incapacity and agent's authority work. The End of Life Options Act is a totally separate, capacity required option for terminally ill patients. None of this means that any existing documents are invalid or that people need to rush into the office. If I have any recommendation for the listeners today, it's that if it has been several years since you have reviewed your Advanced Healthcare Directive, it's a good time to take it out, review who you've named, not because the old document is otherwise invalid, but because the law now offers more flexibility, like the mental health care provision that older documents may not have contemplated.
Really smart. Thanks so much, Katie. Thanks for being with us today on Off the Clock. If you'd like to learn more about us, visit our website at pwwlaw.com. Of course, you can contact us directly by calling 302 628 4140 or emailing info@pwwlaw.com. We're here to help you plan today to protect your families tomorrow. See you next time. Anything discussed on Off the Clock is for general informational purposes only and is not intended to create an attorney-client relationship. To obtain the most reliable guidance, listeners are encouraged to seek personalized advice from qualified professionals.